Good afternoon, everyone. We'll give it about 30 more seconds and then we'll get started. Okay, let's go ahead and get started. Good afternoon, all. Welcome to today's webinar on the Supreme Court, brought to you by the American Immigration Council. We're so grateful that so many of you are able to join us today. My name is Michelle Lapointe, and I am the legal director at the Council. I will be your moderator for today's webinar, and I'm thrilled to be joined today by three wonderful advocates who have played a role in many of the cases you will hear about today. Karen Tumlin, founder and director of the Justice Action Center, Omar Jadwat, director of the ACLU Immigrants Rights Project, and Kate Melloy Goettel, clinical law professor at the University of Iowa College of Law. For those of you unfamiliar with the Council, we are a nonprofit organization that believes that the U.S. immigration system should be just, fair, and welcoming. We pursue this objective through a multi-pronged approach, including impact litigation, advocacy, research, transparency efforts, narrative change, and expanding access to counsel for detained immigrants. Just a couple of housekeeping matters. We will be sending out a recording of this webinar, and we will do our best to save time for Q&A at the end, but you can also put questions in the chat as we go along, and the panelists will do our best to answer them. Let's jump in. So in the 2024-25 Supreme Court term, there were actually only 3 pure immigration law cases on the Supreme Court's merits docket. We'll get to those in the second part of today's webinar, but we're going to start with a review of the shadow docket cases that had an enormous real-world impact on immigrant communities this term. Now, the shadow docket is also known as the emergency docket. Justice Kavanaugh recently tried to rebrand it as the interim docket while he was defending the court's interventions in some of these cases. But whatever we call it, it's clear that it's having a massive impact on cases of national importance, especially in immigration. This refers to a series of cases that come to the court on a rushed basis without full briefing and usually without oral argument. And some of the matters that we've seen the court take up on the emergency docket or the shadow docket this year include the administration's ability to fire civil servants, whether DOJ is subject to FOIA, and of course, immigration. That's why we're here. The use of the shadow docket has increased significantly in recent years. During the 2023-24 term, there were 44 cases on that docket. And last year, through the last day of decisions on June 27th, there were 113 matters that were considered on the emergency docket. And another way of looking at this is that the Trump administration this time has filed 28 emergency applications in 35 weeks, if I am doing the math correctly. And that includes matters that were filed just in the past few weeks, which are actually part of the 2025-26 term just beginning. So since the second Trump administration began, there have been several high-profile and extremely consequential immigration cases on the shadow docket, almost always through the government seeking to overturn a preliminary injunction or temporary restraining order that a district court entered. Let's turn to those cases now, starting with the bombshell, Trump v. Casa. So I will hand it over to Omar. Omar, can you describe the path of Trump v. Casa on its way to the Supreme Court? What was the challenge to, and how did it end up there?
Sure. Well, this was a case, the underlying case in Trump versus Casa is about the birthright citizenship order that President Trump signed on his first day in office this round. Immediately after that order was signed, there were multiple lawsuits that were filed that all resulted in injunctions against the birthright citizenship order, some of which were injunctions of nationwide scope. And so the Solicitor General did not try to get the substance of the question of whether the birthright citizenship order was lawful or not up to the Supreme Court quickly. And in fact, as I think we'll discuss maybe later, they've actually moved relatively slowly to bring that issue before the court. But the issue that they kind of pulled out and rushed up to the court on is the question of how broad those orders should have been, the scope of injunctive relief that was appropriate in those cases. All of these, there were basically kind of two sets of cases before the court, um, or out there in the world. One, and before the court, one was cases brought by states that were saying that because of uh, the birthright order injured their states, and they were deserving of an injunction because of that, and that the injunction, as a practical matter, had to be nationwide to protect the states that were suing from the damage that the order would create. And then there were cases brought by uh, organizations and individuals, and where the sort of nationwide scope of relief or the uh, was based on the idea that in order to protect the members of these organizations nationwide, and the organizations themselves in some cases from from being harmed, again, a nationwide injunction was required. So that question is what uh, those questions is what the Solicitor General pulled out and rushed up to the court in the on the shadow docket to consider.
And what did the Supreme Court ultimately hold in the Casa case?
Um, it's actually like it's a little hard to answer that in a super clear nutshell, but the Supreme Court, I think, disapproved. I think it's it's clear to say that or it's fair to say that the court uh, disapproved of the injunctions in the birthright cases that extended nationwide relief to organizational plaintiffs. Um, it sort of left open the question about whether nationwide relief was appropriate in the state cases, in the cases with state plaintiffs. And it made quite clear that a properly constituted class action case could, in fact, be a legitimate basis for nationwide relief. That is a case that pled, within the uh, boundaries of the federal rules, um, uh, that tried to represent, all of the people potentially affected by this order. And so what you've seen since the Casa decision came down is in the birthright cases themselves, or in with respect to the birthright executive order, there have been class actions brought. There were actually class actions brought literally on the same day that the order came down, um, that that sought that sort of nationwide class action relief for folks, babies who would be subjected to the order. Um, and what's happened, in the aftermath of Casa on the birthright cases in particular is sort of twofold. One, there are now multiple nationwide class actions that have been in which relief has been granted. And secondly, in the state cases, the states have actually gone back and in the courts below, sort of had reaffirmed the idea that even under the analysis in Casa, that they're entitled to nationwide relief in those cases as well.
So what comes next in these cases?
Uh, so as I said, the government, in sharp contrast to how quickly it tried to bring up the nationwide relief question, has not been speed walking the merits. And in fact, there was a whole colloquy in the Supreme Court about whether it would even ever seek cert if it continued to lose, as it has done, uniformly, on the question of whether the birthright citizenship order was lawful. The Solicitor General, after some hemming and hawing, eventually said in the Supreme Court, yes, we would seek cert if even if we continued to lose everywhere. Um, they haven't gotten there yet. They're still in the courts of appeals. But the Ninth Circuit has ruled in one of the cases, or two of the cases before the court. The First Circuit had oral argument earlier in the summer, and a decision is pending from that circuit. The Fourth Circuit case is like a little further down, earlier in the pipeline, but all three of these circuits have the question, in some way before them, and uh, I think there's every reason to expect the government to continue to lose on the merits, and which would, you know, uh, eventually result in a petition and this issue, the merits issue about whether the order is lawful or not, coming before the court.
So let's open it up for discussion from the whole panel. Want to talk about what this means for cases now that seek broader relief to block the administration's policies. What are the options remaining? Omar mentioned class actions under Rule 23 of the Federal Rules of Civil Procedure. Let's talk a little bit about what those are and how to go about getting them. And then we've heard a lot about stays under Section 705 of the Administrative Procedure Act. So what can folks do now who are hoping to seek broad relief against administration policies? Kate, do you want to start us off?
Yeah, well, as you pointed out, I think nationwide class actions are one of the best ways to do them. And to bring one of those class actions, the attorneys have to show that there are common issues of law and fact, along with a few other factors. That means that it makes sense for a judge to decide all of these cases together and to give all the class members relief at one time. And so, as Omar pointed out, people rushed in very quickly, lawyers rushed in very quickly the same day that the Supreme Court decision came out to file these nationwide class actions. It should be noted, though, that this isn't a perfect replacement for nationwide injunctions. It takes more work, and you have to show these Rule 23 factors in order to get a class certified. So, if attorneys like Omar and Karen are trying to, and you, Michelle, are trying to rush in to stop a new policy very quickly, this is an extra hurdle, and they can be factually burdensome to bring these types of motions. The class certification itself can also be appealed just like the PI can. And so that's another way that can be overturned. So it is not necessarily a perfect replacement for nationwide injunctions, but it is, possibly one of the best options available. And of course, one of the challenges we have is that in immigration land, we do have a provision that disallows class actions involving certain matters around detention and removal, which are having a moment. We really could use class actions on some detention issues right now. And instead, we're seeing 50, 60 cases all on the same issue by district courts across the country. So really happy we still have nationwide class actions for now, but I want to caution that it's not a perfect replacement for injunctions.
Yeah, and I'll chime in first on like what does it mean to need to bring class actions, and then also say something about the really bizarre posture. I think this speaks to a little bit to the question that we've gotten so far from folks who are listening in. So on the capacity side, right, and we did this in at least one of our cases that we'll talk about later because it also went up on the shadow docket. We pled the Doe case, the Svetlana Doe case, in the District Court of Massachusetts as a class action. And in fact, classes were certified, classes that number over 1 million people. And so I want to say a couple of things, like not every district court judge wants to certify your class. And so you can plead it as a class, you can file the class cert, all of which is extra work. And not every single judge is going to be inclined to do that or to have before them a class. In addition, if you're doing that with class representatives, there's also often in the land that we live in where retaliation is the norm and not the exception, then you might probably have to do a Doe motion, and your class representatives are probably fearful, understandably, of retaliation from the government. And then, should you get your druthers and you have a class certified, you're responsible for the things that come with being a class action lawyer and communicating with your class. And for us, like, again, just speaking in this one case with a certified class of 1 million people, what it takes to actually confidently communicate with your class is an incredible burden on any organization, whether you are like me and you're 14 employees or you're 400. And then top that all off by the fact that we have been seeing a pattern of non-compliance with court orders. It just means that our wins are harder to defend and protect and to bring in the first place. And the last thing I just wanted to say is somebody I think put in the chat like, wait, why are we even talking about this scope of relief? And like, this is in the Constitution. I think, for me, this is a very unique case. It was one of the first things that happened on January 20th, and we had oral argument at the Supreme Court. All the cases we're about to talk to next, we didn't have that. But removed was the humanity and the impact on people in so many ways from this case, because the court and the Trump administration tried to angle this as this scope of relief bombshell that they've been itching to attack for so long, but they happen to do it in something that strikes at the core of our Constitution and who we are as a people. But somehow they neatly put that question off to the side, really stripping the humanity and impact out of the case that we know so well.
Thanks, Karen. And that is actually a theme that we'll see throughout these cases that the government brought on the shadow docket, just a complete divorce from the reality on the ground and how it impacted people's lives. But we're going to move on to a series of different cases now, just for time reasons. And we're going to shift to the cases that involve the government's power to summarily remove non-citizens from the country. And we're going to start with the Alien Enemies Act cases. Again, handing it over to Omar. Can you remind us what the administration tried to do on March 15th of this year when it invoked the Alien Enemies Act?
Sure. In secrecy, the government sought to send initially hundreds, and we think ultimately, had they been allowed to continue, it would have been thousands of initially men from Venezuela, and I think it would have been others as well if they were still if they hadn't been stopped along the way. To send these folks who were in immigration proceedings in the middle of their proceedings in many cases immediately to not to Venezuela, but to the CICOT prison in El Salvador, a notorious place that Salvadoran authorities had said nobody ever leaves, and where people are held in, the most grotesque conditions. So we had been hearing on a Friday that something was afoot, that people were being sent, sort of Venezuelans from various places in the country were being sent to one facility and being told, that they were going to be deported imminently, even though their cases were not in any kind of condition that would make that legally possible. Based on sort of the intelligence we were gathering, we filed a case early on a Saturday morning saying, we understand that these folks, that there's an invocation of the AEA that's been made, and that purports to the AEA being the Alien Enemies Act, this 18th century wartime law, that under the authority of that law, that folks are imminently going to be sent overseas. And so that's kind of how it all started. What happened then was that we obtained initially a TRO from the district court in DC. After the TRO issued, the government nonetheless landed people ultimately in El Salvador and transferred, hundreds of people to CICA despite the order. But they did obey the order to the extent that they stopped sending new plane loads of people under the AEA's authority to out of the country. And then the government, ran to the Supreme Court and actually got the TRO lifted, but not on the basis that what they were doing was lawful, and not on the basis that the courts didn't have any jurisdiction to look into it, but essentially entirely on the basis that the kind of procedural vehicle was the wrong one. That what we should have done is file habeas actions in districts around the country where these men were, rather than a single action in the District of Columbia. So that was the next step. You talk about work multiplying, and this is another example of it, right? Where under extremely tight time pressure, we had to file, numerous habeas class actions or group habeas petitions to try to prevent additional people from being sent out of the country with no due process whatsoever. And we actually won most of those cases. There was one court that was not acting on a petition that we had filed, despite lots of evidence suggesting that the government was going to send people imminently out of the country. And so, in something that I think is certainly unusual for us and unusual generally for folks on our side, we ended up going to the Supreme Court with a shadow docket application and asking the court to put some temporary emergency relief into place so that people wouldn't be sent overseas, and the court granted that request. And so, the upshot is sort of, I think, 2.5 or 3, depending on how you count, rulings, shadow docket rulings from the Supreme Court in these AEA cases that, don't get into the merits of whether the invocation of the Alien Enemies Act is lawful. That's going to, happen, I think, on a slower track in the Supreme Court, but that do, together and individually, really set out a strong principle that there needs to be some availability of habeas courts to review claims that the government is violating your due process rights, even in contexts like the AEA, where the government purports to have extremely strong exotic powers that would in their view extinguish all your rights. And that that's I think one place to draw some encouragement, even if there's a lot of other places in the court's docket where it's hard to be very optimistic.
And you mentioned the cases, or the lead case now kind of being on a slower track. Can you tell us where that case is and what comes next?
Yeah, so the case in which we got this emergency relief from the Supreme Court is called WMM. At one point along the way, it was called AARP for a little while. And that WMM case on the merits question about, well, there's actually several merits questions, but including the question of whether the use of the AEA to bypass, the law is constitutional, in these circumstances, or sorry, legal in these circumstances. That case is now, essentially because it's the one in which the Supreme Court weighed in and issued an interim stay, is now basically the lead case. And we actually won on the merits in the Fifth Circuit on one of the major AEA questions. The government has now filed a petition for en banc rehearing of that ruling. So it may be that, depending on the timing, we're in the Fifth Circuit for quite a while longer before the case ultimately, makes its way up to the court again.
Interesting that they went to the en banc Fifth Circuit and not bypassing that and going back to the Supreme Court, but we'll all be tracking what happens there. There was a question in the chat about what happened to the men detained at Secot, and the answer is that they were sent back to Venezuela in what was deemed a prisoner swap, which is, I guess, an agreement between the US, El Salvador, and Venezuela for Venezuela to send certain prisoners, including US citizens, back to the US, and for the men to be released from the Secot prison in El Salvador and sent back to Venezuela. But obviously, those hundreds of men are dealing with a lot of trauma, and we as a country are dealing with the aftermath of the just extreme violation of their rights.
Yeah, just two asterisks. One is that there's I could spend another half hour on the litigation about what happened to those men, which is actually still ongoing in various ways. The other asterisk, just so folks know, is that according to the United States, it had nothing to do with the deal between, that ended up causing these men to be sent to Venezuela. Or that might be a little bit of an exaggeration. They say they're not a party to any agreement, that the agreement was really between these two other countries. But of course, it's very difficult looking at the facts of what happened and who got what out of the deal to think that anyone other than the United States was really at the prime mover in that transfer.
Thanks, Omar. We're going to move on now to the third country removals case, and I will hand it to Kate.
Yeah, so this case is DHS versus DVD, and as you mentioned, it concerns third country removals. And third country removals refer to the practice of sending non-citizens to a different country than their home country or their country of origin, usually because they have withholding of removal or protection under the Convention Against Torture. So in February, ICE issued a directive encouraging its ICE field offices to use third country removal for people who have withholding and CAT, especially as people were coming in during their ICE check-ins. And then they later issued some extraordinarily minimal process that I would argue amounts to no process about how they were going to notify those individuals that they'd be sent to a third country. So in response to this, a lawsuit was filed in Massachusetts on behalf of non-citizens fighting third country removals. And they argued the policy violated the Immigration Nationality Act, as well as international conventions like the Convention Against Torture. So pretty quickly, the district court did enter a TRO, temporary restraining order. And despite that, the government went forward with more third country removals, first to El Salvador and Guatemala. And then the district court converted that temporary restraining order into a preliminary injunction and set out some very specific things that the government had to do to give non-citizens written notice and an opportunity to express a fear of return to the third country that they were going to be removed to. So they had to give them 10 days notice to express that fear. And if they did express that fear, they could go back into immigration court, reopen their proceedings, or have a shot at reopening their proceedings to fully express that fear. So refusing to be, bound by what district courts say, DHS continued to make plans to remove people to third countries. The first time this happened, it was an attempt to remove several non-citizens to Libya. And the district court issued an order, which they styled as a clarification order, saying, no, I really meant what I said. You can't carry out third country removals. Later that month, DHS removed 8 men to South Sudan, and the district court at that point went further and held DHS in contempt of court. The court said you have to give people some degree of process. And even though these men had already been removed and were out of the country, the court said you still have to give them process. And so you can do it overseas or you can do it here. The US government proceeded to detain those men at a military base in Djibouti in shipping containers while they complied with the court order. Continuing with our theme here, Michelle, this case made it up there to the Supreme Court on the shadow docket, with the government arguing that the district court never had authority to do what it was doing, and the Supreme Court agreed. Also along our theme, no reasoning. I think it was 3 sentences, something like that. So we don't know what the Supreme Court was thinking, but what did happen was that the third country removals were allowed to resume, and that came out in late June.
So thanks, Kate. You mentioned that the court didn't offer any reasoning, the majority, but we did have a dissent from Justice Sotomayor. Can you tell us about what she said?
Yeah, she wrote a little more than 3 sentences on this topic. She was pretty incensed by what the Supreme Court was doing, both sort of in terms of substance and in terms of procedure. She started her dissent with, in matters of life and death, it is best to proceed with caution. And she argued that this was a gross abuse of the emergency docket and emergency relief. One of the things she was really concerned with was that the government didn't have clean hands. They weren't coming to the Supreme Court complying with the lower court orders. As I mentioned, we had at least 4 instances, probably more that we don't know of these third country removals, despite a temporary restraining order being in place, despite a preliminary injunction in place. And it was only because the lawyers were able to rush in and bring this to the court's attention that the court was able to stop some removals and, hold the government in contempt. So she really took issue with the Supreme Court granting emergency relief where DHS was not following the court's orders. This was an opportunity for the Supreme Court to bless the authority of lower courts, and they just failed to do so. One other thing to mention, Michelle, is that this wasn't the last time we heard from the Supreme Court on this case. I mentioned that order about the folks who were removed to South Sudan, and DHS went back to the district court, and the district court said, yeah, that contempt order is still in effect. You still have to give that process. The Supreme Court said, no, everything is on pause, and all third country removals can essentially be restarted.
So since that order, what has been the effect of letting third country removals without due process go forward? Where's the government sending people right now?
Yeah, so as you imagine, third country removals have resumed. We've seen people being removed to Ghana, Rwanda, again, South Sudan. In a recent case challenging removing non-citizens who are from Nigeria and the Gambia to Ghana, a court, held that they could do so and they could continue to go forward with these third country removals. And this really emphasizes just how expansive these shadow docket rulings are, that we may get a final merits decision on this issue, but in the meantime, we are seeing many, many people removed to countries that aren't their own. And a lot of concerns are being raised about whether those countries are removing people back to their home countries where they have stated a claim of likely persecution.
And a question from the audience was whether people are, what's happening to them in these countries? Are they being detained there either before they're sent to their home countries or, for an indefinite amount of time? What are we
Yeah.
seeing?
I mean, in some cases they are. We're also sending people to places like South Sudan that our State Department has, said is a mess. And so some people are being sent back to their home countries. That was what was at issue in the case about Ghana with the folks from Nigeria and the Gamba. And so, yes, things are not going well for the people who are sent to their home countries. In terms of detention, I'm not entirely sure if folks are being detained, but in any case, there are serious concerns about safety.
Thanks, Kate. And really briefly wanted to mention, just because it was such a high profile case that also had its day on the shadow docket, the Kilmar Abrego Garcia case involving a Salvadoran man who had received protection against removal to El Salvador, who was nonetheless wrongfully removed on one of those flights on March 15th and sent to Secot. The district court in that case in Maryland had ordered the government to facilitate and effectuate his return to the United States in a timely manner. The government went to the Supreme Court again on this emergency docket, and in a 9-0 decision on April 10th, authored by Chief Justice Roberts, the court agreed mainly with the district court that the government had to facilitate Mr. Abrego Garcia's release from custody and handle his case as it should have been handled had he not improperly been sent to El Salvador. But the court also said that effectuate was unclear and may have exceeded the scope of the district court's authority. And so after that, action continued at the district court really for months and continues to this date. But it took the government until June 6th to return Kilmar Abrego Garcia, this one individual who it had admitted it had wrongfully removed to El Salvador. And when it did bring him back, of course, it then brought federal criminal charges against him for the first time in Nashville, Tennessee, alleging that he had transported undocumented migrants years before. He was released from criminal custody on August 22nd, but then rearrested by ICE and is now in ICE detention. He was only with his family for a matter of, I think it was 3 days before that ICE arrest happened. And the government, back to this theme of third country removals, is now threatening to deport him again. I think the current country that they've chosen is Eswatini, although that has changed several times. So it just sort of underscores the extraordinary effort that lawyers, that litigants, that advocates have to make to vindicate one person's right, to bring back one person who, again, the government had admitted had wrongfully removed to El Salvador. With that, we've got a lot more to move through, so we're going to pass it over to Karen to discuss the cases that we're calling mass delegalization cases.
Yes, and I'll just note, here we are, we're like 38 minutes in and we're still on the shadow docket. Like, that's where we are in the scheme of things, in terms of like what has been handed down from the high court for folks in our practice area, and how it has happened in these shadow docket cases. So the two cases that I'm going to talk about, I really put under this banner of mass delegalization that occurred within the span of, it was just under 14-day period, 2 cases, both losses on the shadow docket, where over 700,000 people lost work authorization and permission to be in the United States early, where it was literally taken away from them. And so I'm going to talk about the case that I'm involved in first because it's easier for me, and then talk about the TPS case second because it's fascinating, because they are presently up on the shadow docket again. Who even knew that was a thing? So the case that I'm going to talk about first is a case called Spitlana Doe. This is a case I was referencing that we brought in the District Court of Massachusetts as a class action and had a class certified very early on. It is a big old case. We've had 2 classes with subclasses certified involving the efforts by the Trump administration to attack parole, humanitarian parole, all across the board. The larger case involves a whole host of parole programs, the Cuban, Haitian, Nicaraguan, Venezuelan program, or CHNV, Uniting for Ukraine, Operation Allies Welcome, the 7 family reunification parole programs, military parole in place, the Central American Minors Program, the list goes on. But that is how you get to 1 million people. But the Trump administration went hard against CHNV folks for reasons you can all speculate. And what they did for that category of people, who we had over 500,000 people who were in the United States on 2-year grants of CHNV parole with work authorization, is at the end of March, they said in 30 days, we're taking these grants away from all of you. They issued a Federal Register notice and said on April 24th, everybody loses. I don't care if you had 1 month left on your CHNV grant, or if you came in on January the 18th and you had well over a year and a half left. Everyone loses. We take it all away en masse. We believe that, one sentence, we believe that the purposes of the CHNV program have been fulfilled. We're taking it all away. So, we filed all kinds of requests for emergency relief on that, and we won. And that went up on the shadow docket. The stay pending appeal was denied at the First Circuit, and we went up on the shadow docket on that question only, and we lost. And we lost less than 14 days after the TPS case, which I'll talk about next. And it was awful, right? Because of all the reasons that you think, including it was, by all takes on history, the largest removal of lawful status from individuals in U.S. history, all in one fell swoop, all with no oral argument, all without merits briefing, and interestingly, not a single dissent. Nothing, not a word. So just if you're like really nerding out and following these shadow docket cases, this case and the TPS case that I'll talk about briefly next, they come before DVD. So we do get a small dissent there that Kate just talked about, but we're dissentless. Nobody's saying anything. We're just losing in this case. So I will say, as a setup, a couple of things happened. So we are up at the shadow docket. The TPS case loses, but we have a whole second part of our case in district court where the court actually rules. District court rules before we lose on the shadow docket. What is that? Well, in addition to saying we dislike all of these parole programs, we're ending them for over 1 million people, the Trump administration also said, hey, if you're a parolee under any of these parole programs, we will no longer adjudicate, quote, any pending immigration benefits applications for you, end quote. So if you've applied for asylum, if you were being sponsored for an H-1B, if you won the diversity visa lottery, if you were doing Cuban Adjustment Act, you name it, if you were seeking re-parole, everything was paused. So it was like, talk about like lose-lose, right? Like, we're going to take away your lawful grants of status early and your work authorization and all the other things that you're applying for and are statutorily entitled to, adjustment of status through marriage, you name it. We're just not going to do that. So in the pendency of the stay petition at the U.S. Supreme Court, the district court rules, certifies another huge class and says, yeah, that's unlawful. Start adjudicating those. But we have had all manner of compliance issues. Does that sound familiar? And we'll be having a status conference tomorrow on compliance, our not first, but our second status conference on this issue around compliance since that ruling. And then we lose at the First Circuit. We lost the stay pending. We argue after we lose the stay, the regular the emergency relief motion, and we lost just a couple weeks ago at the First Circuit. Summary judgment is fully briefed, and we're just trying to grind out a win in this case in the district court, which brings me to the TPS case. So the TPS case, National TPS Alliance versus NOM, is what it's styled as when it goes up on the shadow docket. And just like there's been so many efforts to strip TPS status from so many countries, I just want to remind folks this was the first one. This was the first one. And so a coalition of many amazing groups file in court in the Northern District of California, primarily impacting Venezuelans. At this time, they notice it as a related case to Judge Chen. He accepts the case, and they win preliminarily. They win, they survive the stay motion in the Ninth Circuit, and it goes up on the shadow docket where they lose. And they're really, to my mind, one of the first big losses on the shadow docket. It's before DVD, it's before our case. They lose. It's crushing. We're sad. We figure, oh no, we're in deep water now. They don't get a single dissent. What is going to happen? But something that I think is so fascinating about the posture that we're in now with this case, and again, this is the first major delegalization event on the shadow docket. 300,000 Venezuelans are losing their TPS early because of this. That group of lawyers goes back into court as immediately as one can to seek summary judgment before Judge Chen. Judge Chen is undeterred. He does a couple of things that are interesting if we're all just following along at home, because the shadow docket loss has happened. The case goes forward on appeal to the Ninth Circuit. It gets argued. The Ninth Circuit hasn't ruled. The briefing on summary judgment goes in before the district court, and then he stays that briefing until the Ninth Circuit rules on the preliminary injunction, on the regular course of the appeal. The Ninth Circuit rules, and it's a win. They're like, well, who knows they don't say this, right? That who knows what the Supreme Court was thinking? We think that Judge Chen is right on the law. This is unlawful. It's a win. And we're after that. Judge Chen rules and says, yeah, summary judgment, this is a win too. He doesn't accept all of the claims that were moved on. And now that has gone to the Ninth Circuit, where it survives. The Ninth Circuit refuses to issue a stay pending appeal on the summary judgment. But the briefing will go in, I believe that it is next week, on the stay pending appeal the second time around. And I think this is really, really a case for us to watch, because the work and the gumption to go try to grind it out and produce a win on summary judgment before the district court and the circuit after a shadow docket loss is significant and important. And the question becomes, is there a way to eke out a win on the shadow docket the second time around when you're in a final judgment posture instead of preliminary injunction? And is the win starting at the backs at all, at least for just a couple of justices who have been issuing stronger and stronger dissents about what in the heck is the Supreme Court doing on the shadow docket? And I'll pause there.
Thanks, Karen. Before we go into some of the other shadow docket cases, I wanted to pause because you set up a really nice segue. What is there about these shadow docket cases, these decisions from the court, if anything, that is precedential? And what are lower courts supposed to do when they get these kinds of orders? Anyone can take this.
I think the lower courts are wondering the exact same thing, and they're scratching their heads, and we're seeing a lot of frustration. Some judges have even been chided by the Supreme Court for not following a shadow docket ruling. I think if you would have asked us this question a year ago, Michelle, we would have said, well, obviously, an interim emergency order is not precedential, but that's not what the Supreme Court is telling us now. And we're seeing a bubbling of frustration. One interesting oral argument, I think from about 10 days ago, was at the Fourth Circuit, where it was as much an oral argument as a therapy session, as the judges were saying, we need reasons from the Supreme Court. We will follow your decisions, but we need reasons. And they were deciding, Karen just walked us through the arc of these cases, right? So they get up to the Supreme Court on a temporary or on a stay of a preliminary injunction. For the non-lawyers on the call, a preliminary injunction is just an early ruling that's supposed to last throughout the case while the merits of the case goes on. And as Karen walked us through just now, these cases go back to the lower courts, and the lower courts are going, what do we do? And so I think that the judges are really frustrated. We saw this in the Ghana third country removal case recently, where Judge Chutkan wrote the first half of the opinion reading like, the non-citizen's going to win. She was frustrated on the facts and the law, but she compared the case to the shadow docket ruling in Abrego Garcia and didn't feel like she had enough authority from the Supreme Court to grant relief. So it's really problematic for the lower courts, but big picture, it would also be nice for the American public to know what the Supreme Court is thinking as it is chipping away at constitutional rights and redefining statutes with no explanation.
Yeah, and there's increasing chatter among the justices themselves, right, about what they're doing, whether it's appropriate, and some pretty vigorous dissents that we'll hear more about in a minute. Anyone else want to add anything about what lower courts are supposed to do or precedential value? Okay. Then we'll move on to another really monumental case where we got an order on the shadow docket just a few weeks ago on September 8th, and this is the Vasquez Pardomo case that the ACLU of Southern California and others are litigating about the roving ICE and CBP patrols in the Los Angeles area. And we have an Angelino on the call, so wanted to start off by having Karen just kind of talk to us about what was going on in terms of immigration enforcement in LA in June.
I thought about this a little bit last night because we had talked about me just like telling you this as a native Angelino, and it actually got me quite a bit choked up thinking back to it. And obviously it's still going on in my home community of Los Angeles, and also, all the caveats, right? Like, I'm just a white woman sitting here in Los Angeles who holds so much privilege. And my community has been so terrorized constantly since the enforcement actions in Los Angeles have started. And I also now know that, we're not alone. And it isn't just the assault that started in Los Angeles and then, moved to DC, and what we've also seen in other places. I know that we are not alone. But I will just say, I'll just pull up on the radar that Los Angeles is really big, the city and the county, and ICE was visible everywhere. ICE was visible. ICE was so visible. Like, there's so many little anecdotes that I could tell you, again, from my perch, which is a perch of privilege. I got off of phone calls to go to the laundromat to retrieve belongings for friends of mine when ICE was raiding the laundromat, and the owner of the laundromat kicked everybody out, closed it down, and they had to leave their keys and purses and cell phones behind because they just ran on foot, right? Others on our staff, were routinely taking their neighbors' kids to and from work. My daughter at her little summer job at House of Pies was routinely calling me and saying, "ICE is outside, Mom. ICE is outside. I can see them." And then I was calling other ED at another organization because her grandmother, who doesn't have status, was living up the street from there. It was constant. It was daily. It was on and on and on until the injunction. Where it slowed somewhat. And within all of this, it was not me. It was if you looked Latino, it was if you spoke Spanish, and it was US citizens all the time. So I'll just stop there. I could go on. And again, like, I know Los Angeles is not alone, but if you've ever been here and you know the scope and size of the city and the county, to know that it was constant and everywhere and visible, it tells you something.
Yeah, thank you for setting that context. I think that the incredibly robust factual record developed in this case told that story in a really powerful way, and in a way that the district court judge understood and did her job of weighing the facts to ultimately enter this TRO. But the Vasquez Perdomo case began as a habeas petition on behalf of two individuals who were arrested at a bus stop in the LA area while waiting to be picked up for a job. As I understand it, they filed the action while they were detained in the basement of the LA Federal Building in crowded and unsanitary conditions, which is, of course, something we've seen in other parts of the country as well during this mass crackdown since the summer and spring. And then an amended complaint was filed on behalf of additional individuals, as well as membership-based organizations like CHIRLA, United Farm Workers, and others, bringing class action allegations. And two of the named plaintiffs were U.S. citizens who were stopped and detained by immigration authorities. The claims were under the Fourth Amendment, as well as the statute and regulations that set the standards for warrantless arrest by ICE. And then there was also Fifth Amendment access to counsel claim in the lawsuit because people were getting locked up and lawyers were not allowed to get to them. And there's I had forgotten some of these details rereading the district court's order from this case, but some of our friends who are lawyers out in LA who are shouting to people, these are your rights and we want to meet with you, and ICE officers honking horns and other ways interfering with their ability to provide counsel. So the plaintiffs here sought a temporary restraining order, an extremely rapid briefing schedule, and what ended up being the main issue that made its way to the Supreme Court was around the Fourth Amendment claims relating to what constitutes reasonable suspicion for officers to be able to stop people and detain them briefly for suspected immigration violations. And the court found that the plaintiffs were likely to succeed on these Fourth Amendment claims. Just kind of backing up, it's well established that under the Fourth Amendment, there's a case from 1975 from the Supreme Court, U.S. versus Brignoni Ponce, that except at the border and its functional equivalents, immigration agents can only stop and detain people after identifying specific articulable facts together with rational inferences from those facts that the person is a non-citizen who's in the country unlawfully. And in this case, it was just a mountain of evidence. As I mentioned, there were 21 sworn declarations submitted by the plaintiffs, only 2 on the other side from the government. And the court made really extensive factual findings, talking about unmarked cars pulling up to bus stops, men in masks with guns running toward the plaintiffs and others, immediately detaining people without asking any questions about their identity. And then, especially as to these 2 U.S. citizen plaintiffs, first was working at a car wash in Orange County when immigration agents arrived. They didn't identify themselves. They asked whether he was a citizen. He said yes, dual citizen of U.S. and Mexico, showed his ID, wasn't enough for them. He didn't have his passport because as Americans, we're not required, we shouldn't be required to show our passport on demand to show proof of citizenship. And they took him away in a vehicle and eventually verified that he was a citizen, took him back to his place of work, and it was raided again by agents later. And then there was another working at a tow yard in LA County, visited by immigration agents on one of these roving patrols. He saw agents carrying handguns and 1 military-style rifle. Again, question about his citizenship. Pressed on that, said, what hospital were you born at? And he said, I don't know, it's in East LA, I don't know the name. And they put his hands behind his back, twisted his arm, took his phone, etc. So all of these indignities that U.S. citizens were made to endure during this period. So basically, the plaintiff said that detaining people without individualized suspicion using a combination of 4 factors was unlawful under the Fourth Amendment, and the court agreed. And those factors were race, language, is either speaking Spanish or accented English, the place that a person was working, and the locations where they were when the immigration agents encountered them. So the court found that these seizures that ICE and CBP were undertaking were not supported by reasonable suspicion, and that there was a pattern of unlawful stops in the Central District of California. On race, the court pointed to Ninth Circuit precedent, now 25 years old, holding that at this point in our nation's history, given the continuing changes in racial and ethnic composition, Hispanic appearance is of little probative value. So that means you can't just say someone looks Latino and that is probative of their undocumented status. Similarly on language, there's good Ninth Circuit precedent on this, that there's a sizable portion of the population who are lawfully present or citizens who speak Spanish as their first language. So that also cannot be a probative factor. And then on locations and type of work, the court basically found that this idea that the government was putting forward that the agents could say, oh, our past experience shows that undocumented people work at these types of businesses like car washes, et cetera, was insufficient under the Fourth Amendment because the suspicion needs to be particularized. That means individualized to the person that they're trying to detain. So the court granted a TRO to enjoin the agents from conducting these types of stops in the Central District of California, which is LA County, but also a few other counties, as I understand it, in Southern California. Went up to the Ninth Circuit. The Ninth Circuit upheld, for the most part, the district court's TRO and agreed that this was part of a pattern of officially sanctioned behavior, and so the injury was likely to reoccur. It emphasized the demographics of this area. 47% of the population is Latino. 55% of LA County speaks a language other than English at home, including almost 38% speaking Spanish. And finally, it found that the temporary restraining order did not run afoul of the Casa decision, which the government had tried to argue. So a lot of information winding up to the Supreme Court, which on September 8th granted a stay of the temporary restraining order, so agreed with the government. Again, this was an unsigned, unreasoned opinion, but Justice Kavanaugh decided to opine in a concurrence about why he thought the government was likely to succeed on the merits in this case. Really kind of alarming language, again, divorce from the reality on the ground and divorce from the factual record that the district court had developed and the plaintiffs had developed. So he basically said, no big deal. If you're stopped and you're a US citizen, you'll be let go promptly once you prove that you're a citizen. Don't worry about it. Where's the harm? I'm obviously paraphrasing, but it's not that far off. And then, he remarkably suggests like there's a way for plaintiffs to get redress here. They can just sue for damages, which, little law nerd aside, it's extremely hard to get damages for violations of civil rights by federal agents. In fact, Justice Kavanaugh joined an opinion just a few terms ago that limited the availability of what are called Bivens claims, which are damages claims against federal agents. And finally, he opines on this case called Lyons, which is a case from the 80s, where basically the Supreme Court found that there is no standing to bring a claim for injunctive relief when, in that case, people had been stopped by the LAPD, Black motorists, and put in chokeholds, really dangerous policing activity. But in that case, the court said, well, you haven't really shown that it's likely to happen again, so you don't have standing to get an injunction. And Justice Kavanaugh opined that that was an issue here as well, that really they can't show that this is going to happen again. Many other things wrong with his concurrence, but we're running out of time, so I'll cut it off there. There's a really great dissent from Justice Sotomayor. Again, it's just a dissent, but I think lays out the stakes extremely clearly, so recommend that you take a look at that. I think we are going to very briefly mention one other case from the shadow docket that went the right way, I guess, for immigrants, and Kate can take us there.
I'm glad we can transition into at least one positive thing that happened on the shadow docket, because I think so many of us are still sort of reeling from the impacts of the decision that Michelle just described. But we did have one bright spot, which is in the case of Utmeyer versus Florida Immigration Coalition. The Supreme Court denied a stay request of a lower court's decision from the Southern District of Florida. So they refused to lift an injunction on a Florida law, which is called SB 4. And that law made it a crime for anyone who entered the United States unlawfully to enter or stay in the state of Florida. This is one of a series of cases that is about state authority to enact their own immigration laws. And by and large, federal courts have been deciding that the states don't have the authority under the supremacy clause in a concept called preemption. And so it's only the federal government that is in charge of immigration laws and crafting immigration laws and immigration enforcement. The judge in Miami found the same thing here with regards to SB 4C and put an injunction in place. And in this one instance, the Supreme Court did not stay that injunction. And so the law remains blocked.
Thanks, Kate. And we have all these other cases on state laws, as you mentioned, that are bubbling up.
That's right. Yeah, including in Texas, where the Fifth Circuit has granted en banc review of their SB4 that is a similar law regarding whether people can come into the state if they are unlawful, and gives really expansive powers to state authorities to prosecute and remove individuals.
Thanks, Kate. Karen, do you want to say anything about another case that might be seen by the Supreme Court soon on the expedited docket?
Yeah, so Michelle was like, everyone get out your crystal balls, like what could be coming? And like one hates to do this, so I'll only do it for my own case, right? Because I'm not wishing this on anyone unless you cut the way of our one victory. But we have a case called Chirla that is pending. Well, we're not sure where it's pending quite yet. It was brought in the District Court of DC. What is it? Well, it is a challenge to a newfangled use of expedited removal. And y'all all know that there's only one place you get to bring such challenges, in the District Court of DC, within a certain time period. And per one of Kate's earlier points, you don't get to class action those either, right? So all those limitations. We challenged 3 new agency documents that applied expedited removal to parolees, whether you came on some form of humanitarian parole or you entered the country at a port of entry through CBP1 on parole. So over 2 million people impacted. And we got a ruling from the district court from Judge Cobb saying you can't, the statute does not allow you to apply expedited removal to parolees. What do you think the word paroled is doing up in there? And we survived a stay pending appeal, a stay from the district court, and weirdly, very weird posture in the DC circuit, but have survived a stay. First, they granted an admin stay. We did not appreciate that very much. And they took quite a while, over a couple of weeks before they decided the actual stay. And when we survived that stay, there was a pretty odd concurrence that says, you know, doesn't fully nail anything in one direction or another, I would argue very strenuously, but does say, well, I'm not sure the government's harmed here anyway, because there's a 1997 regulation that appears to allow, or that does allow, the use of expedited removal to parolees. I mean, we know that. We talked about that in the pleadings and before the judge below. But at no point in the history since 1997 has that regulation actually been utilized to do what we all saw happening, which is why we filed our request for emergency relief here, which was in May, when nationwide individuals were dutifully showing up to immigration court only to have their immigration cases canceled, or pardon me, terminated, and then walking out the doors to have ICE lying in wait to detain them and put them in expedited removal. So maybe, maybe not. That could be a case that could be making its way up to the shadow docket of the Supreme Court soon. Maybe the U.S. government is going to go back down to the district court and ask for clarification on what this all means. We don't know. They haven't filed that request yet. They still could. And I'll just put a pin and say there is another expedited removal case, and Omar can talk about that if he wishes. It's not at that level, but we were both before Judge Cobb on the same day, a really important case brought by the ACLU.
Omar, do you want to say anything about that?
I mean, just very briefly, this is a challenge to the expansion of expedited removal into the interior of the country. So not in the specific, category of parolees, but more generally to people who've been here for 2 years or fewer. You might remember that there was the first Trump administration tried this toward the end of their term. Then Judge Jackson blocked that expansion. That order eventually went away, but they never really implemented expanded ER the first time around. This time, they decided not to wait so long, ordered the expansion again on day one. Maybe it was day two. And so the case that Karen mentioned relates to that new or renewed attempt to expand expedited removal into the interior. Got a good ruling from the district court. Stay application pending in the DC circuit. We're actually going to have oral argument on that, and we'll see where it goes.
Thanks, Omar. I really appreciate everyone sticking with us through these 90 minutes. We are actually going to transition now to the merits cases that were heard in 2024-25. Believe it or not, there were a few, although obviously the shadow docket took up a lot of airspace as well. So the first is Riley v. Bondi. And in Riley, the court considered two questions about the deadline to seek federal court review of a removal order. The first was whether the 30-day deadline to file a petition for review of a removal order with the Court of Appeals was jurisdictional. In other words, if a non-citizen misses the deadline to challenge their removal order, does that strip the federal appeals court of the ability to review the case? The court found the answer to that question was no, it's not jurisdictional. It is what's called a claims processing rule. That means that if a non-citizen misses the deadline, the Court of Appeals is not entirely barred from considering the case, but instead the deadline can be told if the non-citizen shows that they were being diligent and missed the deadline due to extraordinary circumstances. However, a mandatory claims processing rule cannot be told. It can only be waived by the government, and the Supreme Court did not say in the Riley case whether the 30-day petition for review deadline is mandatory. So that's an open question now for the courts of appeals to decide. The second question that was considered and decided in Riley is whether a non-citizen who's ordered removed by a when a non-citizen ordered removed by a DHS officer by reinstating a prior removal order or by entering what's called an administrative removal order. That's for non-citizens with certain criminal convictions who are not lawful permanent residents. But the non-citizen is seeking withholding of removal or protection from deportation under the Convention Against Torture in Immigration Court. In those circumstances, does the 30-day clock start with the moment DHS reinstates the removal order or enters the administrative removal order, or when the immigration court proceedings are finished? And there, the court held that the 30-day deadline starts running when DHS issues the reinstatement or administrative removal order. So what does that all mean? Well, first, it is a dramatic change in the law. The court's ruling overturned decisions from the courts of appeals, except for the Second and Fourth Circuits. And even the Department of Justice had agreed with the petitioner here that the deadline shouldn't begin to run until a final decision on the person's applications for withholding and CAT protection had been made. So what it means now is that reinstatement of removal and administrative removal proceedings have fewer protections than traditional, well, this has always been the case, than traditional removal proceedings. So it's setting up an obstacle for non-citizens with these types of removal orders to get review of the decisions denying them protection. They have to now file their petitions for review before they even know if they're ultimately going to be denied withholding or protection under the Convention Against Torture, let alone any basis for the denial. So all they have is this order from DHS, and they're pursuing their protections in the courts, but they have to file that petition for review 30 days from when DHS serves that order on them. So this is a problem for a lot of reasons, including that unrepresented non-citizens will not know that they have to file the petition for review before their cases are completed. And we don't know if DHS has set up a system to notify them of this yet. And of course, more broadly, there's no right to appointed counsel in removal proceedings, and most non-citizens, well, many, don't have an immigration lawyer representing them, so it will present even more hurdles. And DHS doesn't always give people copies of their removal orders, so they might not have any idea when that clock starts ticking. So it's a complicated decision, but we don't have time to get into nuances. There is a blog that our own Emma Winger did on this case, so recommend that you read that. And Kate, I'll hand it over to you.
Yeah, the next case the Supreme Court decided was the Monsalvo Vasquez case, also dealing with clocks and timing. This case involved the voluntary departure statute, and non-citizens facing removal have the opportunity to take a voluntary departure order in certain circumstances, which allows them to remove themselves from the country voluntarily rather than having the government do it. So typically, non-citizens have 60 days to voluntarily depart or to file a motion to reopen their removal proceedings. And this case dealt with the question of what happens if that 60 days falls on a weekend or a federal holiday? Do you get until the next Monday or Tuesday in order to either leave the country or file that motion to reopen to stop the clock? And while this is a pretty technical question, the stakes are pretty high, because if you miss that voluntary departure deadline, you are barred from many types of immigration relief for up to 10 years. You could face a fine of $5,000. And so, this sort of bright line between 60 days makes a really, really big deal for immigrants who might miss the deadline. In a 5-4 decision authored by Justice Gorsuch, the court did side with Mr. Monsalvo Vasquez, meaning that when that 60-day deadline falls on a weekend or a holiday, the non-citizen has until the next day to depart, avoiding those harsh penalties. And I'll go ahead and go on with the next case, which is Buarfa v. Mayorkas. And this was a unanimous case from the Supreme Court in which they held that federal courts lack jurisdiction to review visa revocations. In this case, Ms. Buarfa filed a marriage-based visa petition on behalf of her husband, and U.S. Citizenship and Immigration Services approved that petition. But 2 years later, the agency revoked the visa. Finding that such revocations are discretionary, the Supreme Court held that federal courts lack jurisdiction to review those cases. And they did that under a provision of the Immigration Nationality Act that says that courts can't review discretionary decisions of the various DHS sub-agencies and the immigration authorities. And so because of this, there is no opportunity to go and get federal court review over a visa revocation.
Thanks, Kate. Buarfa was the latest in a string of cases limiting the court's jurisdiction to review certain types of decisions made by the immigration agencies. What does this mean for agency accountability, especially in this moment?
Yeah, you're right. So, some folks might recall the Patel case from a couple of years back, where the court sort of closed off relief and judicial review of questions of fact underlying certain denials of discretionary relief. So you're right, this is a continuation of a curtailing or streamlining of judicial review. And that matters all the time, but it really matters right now when we have an administration that is wielding immigration laws and regulations in really reckless and harmful ways, and ways that don't necessarily track what the statutes and regulations actually say. And so right now is a really important time to be able to have the power to go into federal court and to get that federal court review that we've been talking about for the last 80 minutes or so, to have federal courts straighten out what the immigration agencies are doing.
Thanks, Kate. And looking ahead to the 2025-26 term, not on the shadow docket, but on the merits docket, there is one immigration case that is briefed up, and that is the Urias Orellana versus Bondi case. This is a case that arises in the asylum context and deals with the question of whether a federal court of appeals must defer to the Board of Immigration Appeals judgment that a given set of undisputed facts does not demonstrate mistreatment severe enough to constitute persecution under the immigration laws. There's currently a circuit split on this issue, and it really raises some important questions about the role of the judiciary in interpreting statutory protections under the asylum laws, and raises some issues of agency deference and the Loper-Bright decision, which we discussed at this webinar last year, which had to do with overturning of the Chevron doctrine and the new rule that courts must interpret statutes, even ambiguous statutes, in the first instance and cannot defer to the agency interpretation in most cases. So that is a case to watch. I did want to raise this issue of Loper-Bright because a year ago when we had this discussion, I think there was some optimism, at least some excitement, about what it could mean in the immigration space, even if it meant that in other sort of progressive litigation circles, it was not necessarily good news because it meant that things like environmental protections and labor protections and things like that had been traditionally sort of expanded by administrative agencies were no longer going to be deferred to. But we thought maybe in immigration, this could open up new opportunities for courts to look anew at statutes that the Board of Immigration Appeals had interpreted in ways that were harmful to non-citizens. So we're a little over a year into this new regime. I think it's still too early to tell how this is going to shake out for immigrants. It's been kind of a mixed bag. Courts have been struggling with how to treat Chevron-based precedents based on some ambiguous language from the Loper-Bright decision. And we had, for example, in a case that we worked on at the council, the Lopez case, which was a Crim-Im case, basically a Ninth Circuit panel resurrected Chevron under the guise of what's called Skidmore, a different case that's supposed to sort of look at the persuasiveness of the agency's reasoning. We sought rehearing en banc in that case, and we were just denied in late August over a pretty vigorous dissent from Judge Bumatai, who is a Trump appointee. So yeah, I don't think we have an answer yet about what Loper-Bright means in the immigration space, but Kate, I did want to turn it to you for what you've been seeing in some district courts interpreting the statutes around detention.
Yeah, I just wanted to mention, as the immigration lawyers on the call will know, that both the Board of Immigration Appeals and ICE have changed their interpretation of the mandatory detention statute at 235B2 or 1225B2, basically saying that anyone who enters without inspection can no longer get a bond hearing and no longer get bond, which means that they are stuck in detention for the pendency of their removal proceedings. As a result of this, attorneys have been rushing in on habeas proceedings in order to get their clients out of jail, or at least afford them a bond hearing. And many district judges have been refusing to defer to the interpretations that ICE and the Board of Immigration Appeals have recently announced. And they're specifically citing, in some instances, Loper-Bright. And one of the things that Loper-Bright in another case called Skidmore look at is, has the agency consistently interpreted a statute in the same way? And in this case, for 30 years, the BIA and ICE said one thing, and now they are reversing course. And so I bring this up just because this could be the first of many interpretations in which the agency sort of flip-flops. And I think we're seeing perhaps a template for what we can argue to courts when there is sort of a decades-long reversal of interpreting a statute.
Thanks, Kate. We're coming to the end of our time, but I know we got a couple of questions before the webinar about the status of DACA and whether there is any expectation that that will be at the Supreme Court anytime soon. And we have Karen here to tell us about that.
Yeah, and I'll do it really briefly with but bottom line, this case is not on the coming to Supreme Court soon trajectory. That's because it actually, I'll just put like a side note, it falls in the category of interesting victories in many ways out of the Fifth Circuit. So just putting a pin, the Fifth Circuit decision, it's not, of course, all of us wanted a full win. None of us wanted the result that said, um, that work authorization could down the line be taken away from DACA recipients in Texas. But the Fifth Circuit saying the deferred action piece of DACA is lawful in all 50 states, period, full stop. And going on to say that nobody's got standing except for Texas. And so if anyone might lose work authorization down the road, it's only DACA recipients in Texas, and we're sending that back to the district court, is so far superior than folks really thought we could get out of the Fifth Circuit. Just putting a pin that the ACLU, I think, just keeps winning in the Fifth Circuit, both on AEA and apparently some redistricting cases. So it's an interesting, provocative question of to not rule out what we sometimes thought were hostile jurisdictions, even on very hard issues. But what is happening before Judge Hainan? Briefs are coming in Monday, 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 Monday. So just this Monday, there's going to be briefing, and we will learn a lot more about. There was a 6-point order that Judge Hainan issued sua sponte on his own, saying on remand, these are all the things I want the parties to brief. It includes everything from what is going to happen with initial applications, because we know there's 90,000 of them pending and no adjudication is happening, even though that's what should be happening. So we could start to see moves. Maybe the Trump administration issues something, right? Saying we're never going to process those. But we'll start to get some tea leaves between Monday, it's a 6-week briefing schedule, and the close of it on that issue, among others. But Judge Hainan did say, is anybody else going to try to show standing here? So we could also get that coming. So take a look in what gets filed on Monday, and we'll know more soon. But this is not on the fast track to the Supreme Court now. I think that's a really good thing. I give a lot of credit to MALDEF in New Jersey, who've been holding it down in this case from Obama to Trump 1 to Biden and Trump 2. They remain on the side of DACA recipients.
Thanks, Karen. I think we've heard some chatter, not to alarm people, but that there have been some detentions involving DACA recipients is not something that we've seen sort of en masse, thank goodness, yet. So those who have it currently are still protected is the bottom line, and we'll see the case make its way through the courts again. I think that brings us to the end of our topics here. We really wanted to thank you all again for joining and for sticking with us through the entire 90-minute period. We know at this moment there are so many other things competing for your attention, and we're really grateful that you joined us today. Also wanted to give my very deep appreciation to Karen, Omar, and Kate for lending us their time and expertise on these issues in the midst of also litigating almost all the cases that we talked about today. It's just been an incredible honor to have you here and to explain what's going on to the public, something that the Supreme Court doesn't always do for us. So thank you very much. Again, there will be a recording of this webinar sent out to all who registered. Please consider, if you're able, a donation to Justice Action Center, ACLU, and the American Immigration Council so that we can continue this work. Thank you again for joining, and take care, everyone.